So I'd like to thank everybody that's joined us here again today for this week's session, and I hope that this will actually give you an insight into how to manage your internal policies, how to undertake mock audits internally yourself, and equip yourself to be compliant in the future. It is quite a hefty session in terms of topic and content. So what I would hope is that we've got a lot to get through in a very short space of time. If you have specific questions, please do feel free to just pop them into the Q&A section, and I'll try and answer those as I go along or even at the end. But if I can't get through to any of the questions, or you have anything at the end of the session that comes up, please write in and we will do our best to answer as many as we possibly can. Right, so to begin with, let's talk about the agenda. So today we're going to cover pretty much really the headline policy, because I think most companies already know that there is guidance around illegal working. There are already fines in place, but want to talk about really the headline changes that have taken place since February and what the new processes are, the new procedures are going to be in terms of undertaking right to work checks and also being able to comply with the new legislation. We then cover what triggers an inspection from the Home Office. Doesn't necessarily always have to be anything in particular, but we'll cover some of the areas where we think that might cause a Home Office to come and visit you. We'll then go through the audit process, just highlights of what is involved and how it's undertaken. We'll look at some sponsor duties you as employers would need to undertake, and then we'll look at an audit checklist at the end of it. Right, so the new guidelines, which we discussed at the last session, were all around really in terms of the new legislation in February that has come into place, a new sponsor guidance that makes it a very, very specific for companies to undertake right to work checks in a certain way according to that guidance to be able to rely on a statutory excuse. So we covered that area in some detail, but this is just to give you context of why there was a change and why people need to really take this more seriously than perhaps they would have done in the past. So what are the changes? And again, this is going to be very high level changes. We know that the penalties have increased. So there's a reason behind that. Obviously, the Home Office is trying to ensure that there is greater vigilance within companies, and I guess over the COVID period and over Brexit, with all of the changes that have happened there, people have got relaxed and comfortable in their situations in terms of systems and processes. And with the increase in penalties, now it's more about vigilance. It's more about taking due caution and taking due diligence within your internal systems and ensuring that we're avoiding illegal employment. And again, this also boils down to the fact that we've got hybrid working, remote working, working practices, which have become common in the workplace, right? So if you think about allowing people across the board, if your policies allow people to work from home occasionally, then one of the reasons that this has also become quite important in the legislation and in the updated policy is that if you're permitting people to have operating a hybrid working policy or a model, then you would be expected to have more vigilance and more tracking and monitoring in your place. And then the question mark also arises that if you can allow people to work remotely if they are sponsored, then do you really need them to be in the UK? So this is kind of a hidden way of the Home Office trying to figure out what is your justification that if you're permitting remote working, but you're bringing people into the UK as skilled workers or any other category, and then you're allowing them to work from home, are their skills actually needed in the UK? So that's something to bear in mind when you are putting your policies together and also undertaking your right to work checks, and also whether you're permitting hybrid working or remote working from home. In terms of going through the changes, I think there are a few changes that you have to think about. So basically, one of the areas that I think people will probably be a little bit more lax about is the European accession workers. So in the past, you had transition period of sort of 28-day grace period, where you could check if somebody had renewed their EU card or had now gone on to settlement. Well, now that's no longer the case, and there is a requirement that you have to actually take steps to ensure that people, even from the EU, pre-2021 have actually obtained the right status, and they are actually working in the UK. With the right permissions. So you no longer have a 28-day grace period. These are actions that you must undertake, and therefore, if it's something that you haven't undertaken, say for the last 12 months or more, then this is an exercise that we would definitely recommend that you undertake internally. It's quite important to note that there are two types of letters that are issued to these EU nationals under the accession. So obviously, the first time when they were issued, they were allowed to obviously stay as a result of Brexit. And then the second time is whether they became settled workers or not. So it's important that you then review whether you now, across the board, any EU workers that were working for you, you have renewed, you have checked that they still continue to have that right to work, and therefore to rely on a statutory excuse. That's an important exercise to undertake. Now, the other change that is important, and again, I don't think many companies probably thought about this before, and historically, I don't think it was an issue, is supplementary employment. So skilled workers, especially, are allowed to take supplementary employment. So if you have employees or if you are taking on people that are on a skilled worker visa and you're hiring them, say, for 20 hours a week on a part-time basis, and you'd like to utilize their skills, it's really important now to undertake a check. So you have to check that they're still working for the employer under which they're sponsored with. You have to check that the job title or this work that you're actually going to offer them or they're going to do is in the same skill set or the job code that they actually came from. And so there's quite a lot that you have to undertake to ensure that you're meeting that criteria. Otherwise, you can fall foul of relying on a statutory excuse. And the Home Office guidance actually goes into quite a bit on supplementary employment. So I would recommend and suggest that you read through that element in quite detail, because they will match the supplementary employment to the certificate of sponsorship that was issued. They will match it to, I guess, the qualifications, the CV, the skills, the experience, and why somebody is taking that supplementary employment. They will also possibly request a letter from the existing employer to give permission to say that they're allowed to take supplementary employment. So I think this is an area that actually requires you to hone in and have a look and consider whether there is any update or any change or in your policies that you need to make before taking on people for supplementary employment, or even if people are going out for supplementary employment. And I think if you have skilled workers that perhaps want to take supplementary employment, they don't always tell you as a business that, well, we're going to go and get part-time job elsewhere. It might be important for you to then perhaps introduce something in your policies, right? So you're protected, that in your HR policies, for example, that if anybody decides that they're going to take part-time work or any extra work, what are the conditions that they need to meet? Do they need to notify you? And I think those are the types of things that you need to really think about internally, just to protect yourselves. And again, this is about protecting yourself from having a statutory excuse in case the Home Office comes in. You've got several skilled workers, maybe they're working part-time in another job, and you're aware and you have good record keeping or you have systems in place. Even if they haven't told you about it, you have the mechanism in place that the reporting is there, and therefore the Home Office can rely on that. Right. So what is a statutory excuse? Really, I think the way that this works, I mean, in the past, there's been a relaxed approach to statutory excuses, because it's about taking reasonable care, taking all the necessary steps a company can take to be able to allow the Home Office to understand the steps that they've taken to ensure that they've done everything they can in their power to allow somebody to work in the UK, and based on the systems and process and the record keeping that they have, that they've taken all those steps. Now, this could be that when you hired somebody, you undertook at the recruitment stage, you looked at their passports, you looked at their right to work checks. It could be that your HR handbook practice has everything that there is in place, and therefore you've not left any stone unturned, and you've tried everything in your power. Now, if you were able to produce that, normally that it would have been enough. Now, the expectation is actually beyond that. So to rely on a statutory excuse, what the Home Office is saying, And there are a lot of changes, right? So we could say, okay, we've seen a physical document and we relied on it. We looked at the pictures, we looked at the date of birth, we looked at all of this, and we were satisfied. But actually now you have to go through a very specific steps. And almost like previously, the guidance was, you don't have to be detectives. You don't have to be really, well versed in understanding fake documents. But now there is an expectation that you have to take reasonable due diligence and care and match documents across the board to be able to rely on a statutory excuse. So right to work checks in themselves, how are they undertaken? Variety of changes to this. So you would need to look at somebody, again, we've had virtual right to work checks where you have to have somebody in front of you in a video with their document next to them. They've sent a copy to you. You would then try to match their picture against all the other details, if it matches their CVs, their qualification documents, etc. But actually, given all the number of online checks that are now available, whether it's through your British nationals or your EEA, Irish nationals, settled workers, they also have a digital online check that you can do to check right to work, but also with the Home Office right to work checks, the share codes that we've got. And now at the end of the year, we've obviously got the online checks that are coming in as well. So there's a lot of variety in terms of how you can undertake a right to work check. And it's really important as companies, as employers, as HR specialists, that you actually familiarize yourself as to what is acceptable and what isn't. It's quite confusing. And we've had lots of different areas where clients say, but I've actually, the person can't physically be in the office. Can't we do it in the world of remote work? Can't we just do it virtually online? We can see them across the board. But there is an expectation that you have to see the physical document. You have to match the photograph. Is it a close enough likeness to the person? Does the date of birth match with date of birth on other documents that you've undertaken? So there is a much higher degree of expectation in terms of the right to works you've taken, and then the record keeping. So, I mean, in my career, I've actually undertaken so many audits. It's unbelievable. I've attended with the Home Office, I've done mock audits, and time again, when we've had conversations with the Home Office, they've always said, we can expect reasonableness to a certain degree, but we don't expect people to verify documents or, and there was an expectation that you would sign a document. Then they changed all of that and said you don't need to sign a document and date it on the day that you checked it. But it's all changed again, right? So as of February, now we're actually expected to be masterminds. I mean, again, I don't know if mastermind is the right word, but you've really got to take extra care in terms of how you're doing these right to work checks. So you may, again, for people with high volume migrants working in the company, or people who have much higher volume of staff, so we're looking at the larger corporates, the multinationals, I think there has to be a very, very robust system in place where either it goes into a recruitment department where all of these right to work checks are done properly in line with the guidance, so it takes the burden off HR, but there has to be a process in place to ensure that it's done according to what the code of practice is saying. Because any deviation from that may mean that you can't rely on a statutory excuse. So supplementary employment I've touched on, but I think it's really important that, again, I refer people back to the guidance because there's a lot involved with that, and I'd like you to ensure that you actually read it and so you can put the system in place. So audits themselves, they can be announced or unannounced. And we've previously touched on the fact that if it's announced, it means that the Home Office will write to you, send an email, and they will say, we would like to undertake an audit. They will offer you a date on which they will probably attend your premises. But you can change that date if obviously that date isn't convenient. Now, that's a luxury. Normally, they would say, we're attending on the 1st of April and we're going to be there at this time. We expect you to have this available. We may even do this. And they might give you an instruction sheet as to what to expect. However, the majority of audits are unannounced. And when they're unannounced, they will actually come. They will attend the premises which are on the license, so the address that is on record for them. They will usually arrive and ask for either the authorizing officer, if that's the person that they have on record, or the key contact and the level 1 user. I'm going to put my glasses on because I can see some questions popping up in there, but I'll probably wait until the end before I answer them, just to make sure I keep the flow going. So unannounced audits, when somebody arrives at the premises, I think one of the key things that I've had is a client will call up in panic and say, oh, we've got the Home Office at the front desk asking us that they want to undertake an audit. My question is always going to be, you've got to really consider whether you're in a position to be able to actually take this audit. Now, if you're not the named person on the license, you don't have access to personnel records, or you don't have access to information that the Home Office needs, then it's actually literally impossible to undertake an audit. In a world where we live with GDPR, we live with all kinds of security, accessing people's personal data, etc. It's not always possible that if someone turns up that you're allowed to give them access to this information, especially if you don't personally have access to it either. So what I would generally suggest is just being very polite and saying to the Home Office that the person who is responsible or the person who has access to all of this information isn't available. What I have seen quite often is even when a company goes and says that to the Home Office, they say, okay, fine, we will come back another day for the data and for the files, but we would just like to ask you a few questions. So what I would say to that is, if you're not able to answer the questions because A, that's not your day job, or you're not familiar with managing right to work checks or understanding what the nuances are with handling this, you've got to obviously be robust, because unless the Home Office have a warrant and there is a reason for them to inspect and enter your premises because some complaint has occurred or they've got evidence of that, there is absolutely no reason why you can't rearrange that audit. So that's the advice I would give, that if you're not prepared for it, you're not ready for it, or the right person is not there, then you can always speak to them and rearrange. And sometimes they will come back the next morning, right? At least it gives you an opportunity to speak to the people that are involved and get your house in order before you undertake that. So that's on unannounced and unannounced audits. Just to give you an example, it was once an audit that happened on Christmas Eve. I believe it was a good few years ago, and most of the staff obviously on Christmas Eve would have left. It was in an industrial park. It was quite a large energy company, and the Home Office turned up, and there were probably 3 or 4 skeleton staff still waiting and probably waiting to go home. And it was 4 o'clock in the afternoon, and the Home Office insisted that they wanted to carry out this audit. But unless they had an absolute warrant to enter the premises, there was absolutely no need, because there weren't the right people. HR department was completely closed down. Most of the staff had gone by then, so it didn't make any sense. And I think companies completely confuse themselves, that they feel they fall under the pressure, they have to answer questions, but there is no pressure, because there is no reason. They're coming to undertake a inspection to see if the records match whatever they have on record, and there is no reason why you can't rearrange that unless there's something else that the Home Office actually presents themselves with, and then there's no reason for you to actually deal with it. Even then, we would recommend getting legal advice, or even getting your legal representative, if they can attend with you, to be present while that audit takes place, especially in those circumstances. So what triggers an audit? Now, as I've said before, you do not necessarily need to have a particular event taking place for an audit to be triggered, right? However, if you've had structural changes in the organization, there's a merger, there's an acquisition, there's a takeover, there's a transfer of staff through 2P, maybe there's been a large project and you've suddenly had an influx of people on skilled worker visas, then that's a trigger event, right? So there's activity on your sponsor management system, on your reporting side, and the Home Office then starts to look at the details, probably have a team that looks at all of that information and then makes an assessment as to whether that should trigger an audit or not. If you then have an influx of allocation increases, for example, some companies, they have projects and they might have 100 to 150 people that need to come on site to work for them. So as a part of that project and that contract, they will issue 100 to to 150 certificates of sponsorship to these people. So if that level of number increases and you've made that request for defined cause or undefined cause on the system, again, something like that could trigger an audit or trigger questions. So it's just about having your systems in place, and it doesn't mean that you can't do it. It just means that having your record keeping aligned so that if any questions are asked, you're ready to answer them. If companies have not had an audit taken place for a number of years since having had their license, then that's another reason why, especially in 2024, I think there is a review process going on as to the types of companies there are, numbers of migrant workers that work within it, then that might trigger an audit. And then the one that's most common, which I think commonly missed, I think, is within companies, is when you have change of personnel. So if your authorizing officer leaves, your key contact leaves, and they leave without any instructions or notes for their successors to be able to manage that. And we often have people coming in a panic saying, we have no access to the SMS, we don't know where the information is, it was with our predecessor, we don't know where they stored it. And that, I think, is really important, because quite often you think it's straightforward. And in the past, it has been that you would go to the Home Office and say, I'm sorry, we can't find our login ID because the person has left. Now, what do we do? Well, that shows the systems are not robust enough in your organization, and therefore there is a reason to come and undertake an audit. So it's really important that if you've got staff that are leaving, you actually ensure that anyone that's taking over that role has access to the system, or there's enough notice to be able to get themselves access to the system, or you deal with your legal representative to ensure that you notify that these people are leaving. Because quite often I'm seeing more and more lately where people have left and somebody will come in 3 months later and say, well, they left 3 months ago, but no notice was given on that either. So that's a breach and a non-compliance, because if you've got somebody that's registered on a license and they've left, well, there's a requirement to report. And if that hasn't happened within the time frame, then that's a breach in itself. So you can't rely on a statutory excuse. Right, okay. What else triggers an audit? So the audit process. So let's just say now you've got the immigration officer that's come in to your premises, you've allowed them in. The process involves, they will meet with the people on the license. It doesn't always have to be the authorizing officer, right? So the authorizing officer can be, a very senior person. They're never involved in the day-to-day business. They're not involved in issuing certificates of sponsorship. They're just the person that's responsible for the license. So very rarely do I see authorizing officers being the people that are answering the questions. It's usually the person who has an understanding of your processes and systems. So it could be the key contact, it could be the level 1 contact. Quite often your legal representative may also be present at this audit. So they will basically go through an interview process, and the interview process consists of a questionnaire. It's quite a long questionnaire. They will ask you a number of questions about your organization, just to match, how many sites you have, where are you located, what kind of people do you employ, what kind of roles do you have open. And you have to be very cautious about these questions, because there's another example I have where we had a immigration officer turn up at a large client. They sat in a meeting room, and in the meeting room, they wanted to look at records. And so the HR director, she opened up the screen in the meeting room and she looked at the system. And while she was looking through it, she opened up a page of prospective candidates for various positions. And this immigration officer just caught whiff of the names, and he said, right, I want to see this page. Right. And she said, but these aren't employees. These are prospective candidates that we're interviewing. And he said, yes, but I want to see their names. I want to look at their CVs. Luckily, we were able to say, well, no, actually, you can't, because this is not information that you're privy to. They're not employed by the client. They're not sponsored migrants. They're not people that are within the organization. And we haven't even decided whether these people are going to be employed. So you can see how easy it is to divert attention to data that you do not need to provide the Home Office with, right? So you've got to keep a focus on what is important and what is required, and familiarizing yourself with the process is really key to that. So as part of that, they will go through the questionnaire, ask you random questions, They will then want to, after the questionnaire, they will also want to look at the files, the personnel files, your policies, and your record keeping. 99% of the time, when I've undertaken a mock audit, most of my clients have always said confidently, we are 100% fine. We've done this, we've got a hold on it, a whole team has been working on this for the last month. Right, go ahead and do your mock audit, do the worst you can do. And we'll go through the interview questions and it will be absolutely fantastic. They'll have answered all the questions, they'll be happy. Then we'll get into the files and the interview questions don't match what's on record. And that's really where I think the gaps are, is to ensure whatever you're saying matches with the evidence that you have. So it's key to consider that. Then the other part of the process is the Home Office will also speak to random migrant workers. So if you provide them with an Excel sheet of all your staff and the number of sponsored workers there are, they may pick and select a couple of people they want to talk to. And what they will do is they will have interviews with them. Again, the interviews they have with the migrant workers need to match the records that they have. So if they've got an employment contract that says, I'm a structural engineer and my salary is 75,000, and the contract says your salary is 60,000 and you're a pipeline engineer, that's a question mark that they will probably look at. So I think you've got to ensure that any record keeping, any migrant workers that you have, there's robust policies internally to ensure that if anyone is going to be spoken to, that they also know how to answer these questions. So they even sometimes delve into, well, how did you get this job? What's the role? Well, what was the process that you had to go through? And your reporting mechanisms, and when you're absent, when you're on assignment, who do you notify? So if people are going on assignment, and people do travel quite a lot frequently, it's the expectation of how frequently are you reporting that, and is it even necessary to report? So once all of that is complete, the interview process is complete, the record keeping is checked, the files have been checked. What the Home Office generally do is they don't give you an answer immediately. They say, we will take our notes away and we will evaluate our findings when we go back, and then we will come back to you with a decision. We have had situations where the Home Office have taken months to come back, maybe because they ask for more information when they go back and they consult, and they have asked for more details on records that maybe they weren't able to see or they weren't able to make a decision on. So then you have to make a decision as to what you're going to send them. And then once the decision is made, basically you're notified. In most cases, I would say between 2 to 3 weeks, the Home Office notifies you of the outcome. And normally, with all the audits that I've undertaken, they've been pretty much fine. It's, quite grave circumstances, I would say, where people we'll go through what the outcomes could be if you fail an audit. So examples of non-compliance. So if it's really important to understand that, again, these things can be missed quite easily. So a sponsored worker's job description, quite often, if you've promoted somebody or they've switched departments and they've changed their role and they've started in a project team and now they've gone to a very specific role because they were seen by a different manager and the manager thinks their skills are more tailored to a different department. And if you don't consider either they fit in a different job code or you haven't updated the system to say that their job role has changed, that is an example of non-compliance. If your sponsored worker contract was terminated or they resigned and you did not report that on the system and there's no notification of it with a date and you haven't got a record of it, that's an example of non-compliance, especially within the right time frame. So you have 10 working days to do the reporting as well. If they've switched into a different immigration status, so if they had sponsored skilled worker visa and they have either become a dependent or they've gone into settled worker status and you haven't undertaken a report on that to update your system, again, that would be considered non-compliance. So various other things, like if your business changes names, if you sell part of your company, if your organization gets taken over by another organization. I mean, these are the intricacies of making sure, and a lot of the large companies are quite good at doing this actually, because as soon as a takeover happens or an acquisition happens, we go through a whole reporting mechanism of providing the Home Office with as much information as we can to ensure that they're up to date with all the requirements and so forth. If anyone in the organisation is convicted of a relevant offence, again, I would assume policies are in place to make sure that they notify the company internally, and so therefore any change that needs to happen on the system would also happen there. So these are just generally some examples of non-compliance, but there are going to be many more as well. And if people have examples that they want to check in, please do feel free to. So what are your duties as a sponsor? We went through a period where there was a very robust system when the points-based system first came in, that you had to do X, Y, and Z. It was very, very clear what companies had to do to ensure that they maintained their duties, and there were 5 areas of HR that they covered, and they would ensure that they maintained that. But over the years, what has happened is there's been a laxed approach. It's been, okay, fine, you don't need to do your annual checks anymore. Okay, fine, as long as your policies are in place, you don't need to do X, Y, Z. And so people have gotten used to this kind of relaxed approach to, as long as I'm doing the right thing, I don't have to go overboard. You know, we're a big company, or we're a company that doesn't, you know, we've taken on genuine workers. There is no reason for us to be non-compliant or to be in breach of anything. That's all fine in the mind, and it's fine how you think with intention. But if you can't back it up with your record keeping and your tracking, then unfortunately, with the new code of practice and the new updated guidance, it could be a problem. So the Immigration Act actually covers illegal employment and making sure it's preventing anyone from doing so. So it goes so far as now saying maintaining migrant contact details. So keeping that up to date, their phone numbers, their addresses, if they're moving. And again, with hybrid working, when people are working in different locations, they're working in different places, it's really important that you keep up to date with where they are. Sometimes they might say, I'm working from home, but actually they might be in London, but they may go to Scotland because they may be working with a family member. So they've moved location completely, but you wouldn't know any different. It's really important to make sure that you have up-to-date information on where they are. Then in terms of record keeping is retaining the documents on file, right? That's so important for a statutory defence, because if the Home Office says, you've just told me your person works in London, they come into the office 3 days a week, and then 2 days they work from home. I've just had an interview with that person, and they've told me, yes, they work from home, but they're actually working in Scotland, and the address you have on file is actually completely wrong. How do you then rely on a statutory defence, right? Because it shows that your systems there's a gap somewhere and you've fallen foul of the rules there. So it's important that record keeping is up to date and completely accurate to rely on that defence. So monitoring and tracking. So setting in place triggers for yourself, notifications that will say to you, you know, sometimes it's every quarter. Do we need to check on people's home addresses, mobile numbers, any information? So for example, even I would say, if they're a dependent and they're working for you, they're not sponsored, and they are here on somebody else's sponsored worker visa, and let's say their relationship breaks down. If your policy says that if you notify us of change of circumstances in your personal circumstances, you've covered yourself, because you fulfill the obligation to say that we have told everybody as part of their employment that they must notify us within a certain period of time. If they haven't notified you, then the onus is on them. So it's making sure you're tracking and monitoring people's change of circumstances and keeping a note of that. And I mentioned earlier, level 1 users and authorizing officers, key contacts, all of those personnel, items like your address, your premises, your leases, all of this is really important to keep up to date, because if on the license you're at an address in Edinburgh, and then the Home Office is if the Home Office is visiting you in Edinburgh, but actually vice versa, you get the gist of what I'm trying to say in my head. If your address is different to what's on the system, that triggers a reason for the Home Office to say, well, actually, this is non-compliant, because you haven't fulfilled your duty as a sponsor to notify us of any of those changes either. So it's really important that happens as well. So maintaining these duties, I think it's really good practice for you to just check. Your initial compliance would be, how is your license set up at the moment? Does it have all the correct details? Does it have all the correct personnel? Do you all have the right levels of access? And are you able to access all of your sponsored migrants? So you might need to do an exercise whereby you've had numerous people working for you, but were they all notified that they left the company, or that they moved on, or their status is changed? So making sure that initial compliance piece, that everything that's on the SMS is actually as it should be. And if you've got an internal checklist, you can check against that. Then ongoing compliance, ensuring that any data is checked on a regular basis. So again, putting triggers and notifications and reminders on your systems to say that we will check periodically. We will check our systems, we will check our recruitment processes, we will check any of our migrant workers and notifications to them. How often are they giving us their details, and how often is our team actually going out and collecting that data? So reporting duties, being familiar with the time limits on your reporting duties and what it is that you need to report, because sometimes too much information is not helpful either. So you have to be cautious on what you're reporting, and just report what is required, what is expected, and nothing more. And I think as long as you're compliant with that, that's enough. So change of circumstances can be reported. So any job changes, salary changes, change of a location, as an example, any work conditions, any duties, or any terminations or anything like that. All of that is part of a duty that you have to adhere to. So an audit checklist. I would really strongly recommend assessing internal policies. A lot of clients have asked for immigration policy on basically setting out so that there's internal, like you have your HR policy and your recruitment policy and sickness policy, you should have an immigration policy which sets out who are the people that are on the license, who do your internal employees need to go to when they have questions, and it sets out all of the do's and the don'ts, right? So good practice, and allows you to ensure that you also have guidance so that if people are changing roles or moving on, or you've got new people joining your team, there's clear guidance on what the policy is. Again, reviewing your hiring policy in terms of right to work checks. At what stage are you taking them, and what documents are required? It's important to check that. Bringing your recruitment team and aligning them and collaborating with them to ensure that they align and understand that they follow the same path. And so if they've got a checklist of information, at what stage are they doing it, and what stage are they then passing it on to HR, so that you've got it on record on your files, because it's not recruitment or the hiring team that will be the ones in question. It will be the HR team that is in the firing line. So it's important that you actually collaborate to create a policy or a process or workflow that hands over correctly. The sickness and absence policy. This is also important with hybrid working, and also an expectation of notification and who people need to notify when they are sick, and how quickly they need to notify. A lot of companies have quite robust policies about that, but I just think it's ensuring just to review it again and make sure it captures everything according to the new guidance. Employee handbooks are extremely important, and it's because you catch everything else. Right, so change of circumstances, change of addresses, change of relationship, change of anything. You can capture all of that into the employee handbook, so that if anybody has a change of circumstance, the obligation is on them. And maybe once every 6 months, you send out an online handbook to everybody to remind them that it exists, and to refresh their memory of any conditions, so that if anybody remembers any payroll changes, for example. And we would also, as I said in this previous slide, is the SMS details and the internal records. This is of your own staff, AO officers and level 1, because this comes up. The number of times this comes up, I can't emphasize. It keeps coming up. Despite telling people that it's important, it still falls foul of the rules. Then having training internal sessions. Now, what I've seen work really well is getting buy-in from senior management. Senior management don't quite understand always the importance of this, right? But if you can show them the level of fines that you're likely to incur as a result of a breach or a non-compliance, I think you'll quickly get their buy-in. And the way that it works is do some training sessions around it, do some workshops. And I've seen people actually being surprised because they didn't know. And education, learning, and development with any of this type of stuff, I think it's really important for people, because suddenly then you get their buy-in. If you get their buy-in, then you've got better policies, better processes, and everybody understands what's involved. We would also suggest practicing with mock audits if you have the ability, or if you've got legal representatives or support, or if you're able to get some specialist help with this. Practice mock audits. There is nothing like it. It identifies gaps immediately, and all it gives you is an opportunity to fix those problems before the real audit happens. Maintaining records for up to 6 years. So quite often we've got GDPR rules, we've got all kinds of rules. We can't hold data for a certain number of years, but for the purposes of the Home Office, you have to keep certain records and files even after people have left, right? So you have to show them to the Home Office that you actually were compliant at the time. So maintaining records is absolutely critical. We've touched on unannounced visits and how to handle those, so I think that's okay. And then maintaining transparency and accountability, right? So being as honest as you possibly can, as long as your intentions are right. There's absolutely, and I always say it's not a witch hunt. The Home Office are there. You can get caught out. The stories that I have on some of the, goodness gracious, some of the audits that I've attended. I mean, there was one audit that I had, and it was a huge oil and gas company. Their managing director came all the way from overseas to attend this because he wanted to oversee it himself. And we were in a large boardroom. I mean, it was huge. And they took the audit so seriously. So we waited. The Home Office, 2 ladies turned up 15 minutes late, and it looked like they just rolled out of bed. And their hair was, I'm just going to show you. It was like this. And they walked in and said, "Oh, sorry, just didn't realize where the time went." And then she went over to the desk. She picked up a piece of paper. She said, "Would you mind if I just borrow your piece of paper and your pen?" She turned it over and she started writing notes. It was an absolute shocking audit. I mean, obviously, no doubt we complained about it, but these are serious businesses we're talking about that go out of the way to put these systems in place, spend money, resource behind it. You put out the policies, you say this is the law, you tell us this is legislation, you tell us this is what you're going to expect in terms of fines. Well, at least take it seriously, right? Send in people that are professional, that are going to deal with this in a manner that is, that it deserves. And therefore you can have a communication, and you are there with the right intention to put the systems in place. And that's what you want. So be aware of that, and we hope that the Home Office has addressed that issue. We then had a really good audit, actually, with one client where an officer came in, and she was so good that we actually used her as an example for doing all of our future events. And she would come and she would talk to people, and she said, "This is how I do my audits, and this is how you would pass, and this is how you would fail." And so, you get good officers who are actually quite supportive and cooperative as well. And then you get the other types as well, which are kind of borderline, where they'll come in, they'll be confused because they don't understand the immigration side of it. They don't understand hiring policies. They don't understand what a company is doing. And they're not commercially astute to, or, what they should be looking for. They just go by a textbook and a piece of paper. And so it's really important that you are actually able to tackle that and handle that. So we had one where the client had a project with a very large overseas contractor, and they were all on their site and premises, and they were there as business visitors, and which was fine. They were doing, kind of design and engineering work, and they were they were having meetings, but it was all decided because it was an unannounced visit, and they all thought, we're not doing anything wrong, let's bring them in, fine. And they just talked about the business visitors. Oh, yes, we have all these people on our premises, but they're business visitors. They took that away to say, well, actually, they should all have work permits. It's just more time spent on trying to justify, satisfy, and provide representations in areas where perhaps they've just not understood the situation. So again, just draw caution to information that you share, to how you handle it, and to be able to deal with the inspection officers in a way that, be confident And I think being equipped and being aware and knowing what to expect and undertaking mock audits and having the right policies in place will make you that confident that you can answer. You don't have to answer everything. If you don't think you can answer something, you don't have to answer it. Right, and you can get more time for it. Because again, I don't see this as a witch hunt. I see this as a collaboration of ensuring that we have all the systems in place and we're complying, we're doing what we're meant to be doing, and therefore, there is no reason for them to suspect. It goes in a different direction, I think, when you're fearful, and HMRC audits often have created that level of fear amongst companies, but I don't see it that way. Right, visa tracking, which is very, very important. And again, a lot of people track that through their Outlook, through calendar reminders. But it's really important now that any permissions, any limited leave to remain, not just for sponsored workers, but across the board, is tracked robustly. You have to put there will be companies that probably have a loose system in place, but I think you need to find technologies to support that ensures that you're getting the notifications at the right time and that you can actually then demonstrate that when the Home Office attends your premises as well. So what are the risks of getting it wrong? We probably talked about that till we're blue anyway. So the risks, we know, the civil penalty, which is obviously is tripled in size. We know that. Now, there are also criminal sanctions, and a lot of people aren't aware of that. So if a breach is found, and it's a serious breach, the criminal sanctions are up to 5 years in prison for condoning the employment of legal workers, right? Not making the report and not telling the Home Office when it was time to tell them. There is also a financial and reputational loss. Penalties can include things like enforced debt action, disqualification of directors. Now, when I've done workshops in companies for management, particularly, because I often think it's really important for the board to be aligned with HR and understand, and HR need to have a seat at the table, because these are quite serious implications, and an organization needs to be in sync with the responsibilities that they're actually facing. So when we've done these workshops, I think the number of people that are left mouth wide open, not realizing the consequences of getting this wrong, and they're thinking, oh, well, there's just talent that were here, they're working, these are just administrative tasks, but they're not actually administrative tasks, because they're quite pressurizing. They have a big onus and a responsibility on somebody. And if you're good at your job and you know what you're doing, then you take your job very seriously. Then it's important that management also listen to that. So it's important then to ensure that you're actually educating your management alongside your teams as well. So not only can they get disqualified or to cease trading, revocation of license, suspension, or downgrade as well. So remedies. So it's really all about the statutory excuse. So even if if a breach is discovered, or even if non-compliance happens, right? So let's say you haven't reported somebody's change of employment, or somebody's salary's changed, or you haven't reported because somebody's moved location. If you have the systems in place and it's just something that's just dropped through the loop because the onus was on the employee to notify, right? But you as an organization have done everything and you've got all the steps, then you can still rely on the statutory excuse. And I think it's all about proving it and having the tick boxes that you've got to ensure that you've done everything as far as you're concerned to be able to satisfy the immigration officer that was the case. If your history of compliance is also intact, and they can see that your records are all up to date, and this is probably one or two that have dropped through the system, then I think you tend to be fine. Now, if you're challenged on that, again, would not advise anybody to comment, but to seek advice before providing commentary. But there are lots of remedies that you can have and you can put in place and make representations. We've had people where the Home Office has decided to downgrade to B, which means you can't issue any certificates of sponsorship, and we've challenged it and they've had to reverse their decision because they've just misunderstood the circumstances. So it's just really about how you communicate to the Home Office as well. Right, so that's the end of the audit masterclass. I hope that I've covered as much as I could in terms of the time that's permitted. There's a lot. I mean, there's a whole list of what you could keep on file and so forth. But happy to answer those questions at a later date. In terms of next steps, I think what I will do is I'll answer some of the questions. I can see them already here. So let me quickly go through those because I know we've only got 10 minutes. Right to work checks. If you have the Gov website check, do you still require, one second, do you still need to store a photo ID alongside the Gov share code? Yes, you do. You would still require a photo ID along that to keep on file, on record, because you're still required to undertake due diligence on, does the photo match the passport? Do the details match all of the other documents? So in terms of being robust, you would still be required to ensure that you have all of those on record. How can an employer balance the need for data privacy and the need to satisfy the statutory excuse criteria? Okay, I'm not entirely certain on the question on that, but the Home Office has a right to view data and to ask for any information on sponsored workers. If they've come to the UK, they probably hold that data anyway. So I think that would not be covered. So if you, as part of your employment checks, as part of your right to work checks, you have to request certain data anyway. So it's not covered by data privacy, and therefore you would have to hold those records on file, and that's the only way you can rely on a statutory excuse. Next question. I have worked as a mechanical engineer under a Tier 2 visa. If I work 20 more hours in a part-time capacity, will that amount be taxed? Okay, so I mean, this is more of a tax question. So I would suggest you speak to a tax advisor, because I don't know the actual detailed circumstances of your individual case. So it would be wrong for me to give you advice on this without understanding more background. But I'm assuming that if you are working and you're employed and you're PAYE, you would automatically be taxed anyway. Right, so next person, we introduced IDVT last year for British and Irish, which we thought was sufficient, but we have been told that this is not enough. You also have to do a day one passport check as well and sign and date the passport as well. Is this correct? And do you also need to do a passport check for EU share code employees, or is the share code number sufficient? Unfortunately, with the new guidance, that everything that we have seen and what the Home Office have said, and I have actually spoken to the Home Office about this, is that they are saying they've gone back to the old rules, which is that they want people to have a copy. They want you to see the physical copy. So it is important now to check the documents on their first day, and there is an expectation that you even check their photos to see if there's a real likeness, and their name, their date of birth matches across the board as well. So unfortunately, yes, that is the case, and it applies to the EU share codes as well. Now, with the biometric cards, as we know, at the end of the year, if that's changing, it'll all be online. And before you could rely on a biometric card, but now that's an online check that's required, so that will be automated, but you still need to see physical passports for now to make sure that you actually rely on a statutory excuse, because the most important thing is, how do you rely on a statutory excuse? Any more questions? I can't see any more questions. So I just wanted to add at the end here that we are hosting another webinar in 2 weeks, which will cover Schengen. And this will be around British nationals going into the EU and foreign nationals going into the EU. And since Brexit, this has been a real challenge for people, is what can people do? How long can they stay? Multiple entries in different countries, overstaying, penalties. And there's also a new legislation that we're hearing about, which is that there could be an EU consensus type of work permit. So that if you have a work permit for France, you could even use it for other countries as well. So I'm trying to get updates for that. And if we have an update by the time we do this webinar, that'll be an interesting one for you to listen to. So if anyone wishes to come to this, please do sign up for the next webinar. And I very much look forward to seeing you for that. But for today, if you have any more questions around the auditing process, mock audits, checklists that you require, please do write in and we will hopefully provide that to you. Otherwise, thank you very much for attending.